After the safe harbor was invalidated, a new framework was adopted and agreed between the US and the EU, the Privacy Shield framework, that was designed to provide more guarantees to EU citizens when their data are transferred from the EU to the US. But again, the new Privacy Shield framework that was agreed in 2016 didn't change anything in the way Section 702 of the Foreign Intelligence Surveillance Act works and is actually used by the NSA to collect data of EU citizens. The Privacy Shield framework was invalidated by the Court of Justice of the European Union. So this Privacy Shield framework only lasted from 2016 to 2020. And the reasons used by the Court of Justice to invalidate the Privacy Shield in 2020 were basically the same as the reasons that justified the invalidation of the safe harbor in 2015. Following that, the EU companies or the US companies wanting to transfer data from the EU to the US had no other choice than relying on another mechanism provided by the GDPR, which is a contractual mechanism, standard contractual clauses. But under this mechanism, those companies are supposed to bring contractually more guarantees to ensure that the EU citizens' personal data are protected while in the US. However, these standard contractual clauses do not appear to be sufficient with regard to the current Section 702 of the Foreign Intelligence Surveillance Act, which, again, allows the NSA to collect data within the context of specific surveillance programs. For that reason, some companies have been sanctioned in the EU for transferring data from the EU to the US on the basis of standard contractual clauses. Among those companies is Meta, who was fined last May for transferring data on the basis of standard contractual clauses. Therefore, it was urgent to adopt a new framework that could serve as a legal basis to transfer data from the EU to the US. And this new framework was finalized in July 2023.